Welcome to the Divorce Do's and Don'ts show. As you know by now, this is the show that covers all phases and aspects of the divorce process so you can avoid common, costly, and unfortunately sometimes permanent mistakes and have a smarter, saner, savvier divorce. I'd like to introduce our host, Lisa Decker. Lisa is a certified divorce financial analyst and a real estate collaboration specialist in divorce. She's also the CEO and founder of Divorce Money Matters and the organization that brings us this wonderful show, Divorce Town USA. So Lisa, please tell us what we've got in store today.
Well, thank you so much, Marcella, my right-hand lady, my executive assistant, and this show's producer. I appreciate that introduction. So as most of you know, this month we are talking about financial literacy, and part of finance is in divorce has to do with keeping your costs down, your legal, your financial costs all the way around. So we always here advocate a low conflict, cooperative divorce whenever possible. However, we know that for some of you that just isn't going to be possible no matter how well-intentioned you may be. So today we are honored to have with us Jackie Harounian. She is a managing partner at Whistle Harounian Family Law in New York. And Jackie has graduate degrees, and listen to this, folks, in both law and behavioral forensic psychology. I'll let her explain that more. Her practice includes mediation, custody litigation, prenuptial agreements, and representation for business owners and high net worth clients. She has extensive experience dealing with domestic violence and financial controls in marital relationships. And she is a frequent panel presenter and a national speaker on many family law issues, including religious divorce and diversity, cultural sensitivity for judges and lawyers. She has many awards, including 2022 U.S. News and World Report Best Lawyers and Super Lawyers, Top 50 Women Lawyers. And her firm was recognized this year as the #1 matrimonial firm by Long Island Business News. So we have a special guest with us here today, and I am so excited. Jackie, welcome to our show.
Thank you so much, Lisa. Thank you, Marcella, for all of the behind the scenes work. I'm very, very excited to talk about this topic, which I think is a cautionary tale for almost anyone going through the process, and hopefully will provide some advice for people that are in high conflict situations, how to maybe de-escalate and try to resolve issues if they can. Because as you mentioned, it's not always under a person's control, but some things are, and hopefully I can shed some light on that today.
Well, we are looking forward to that. So take it away from here. I'll be interjecting questions as we go.
Okay, great. So I do have a very basic PowerPoint, only a few slides, but if anyone's watching this on their phone or wants a copy of this PowerPoint, there are some points that I want to make. So the title of today's presentation is Stopping the Chaos, Calming the Chaos in High Conflict Matters. Can you see my screen?
It's black right now. We
Okay,
did see it a second ago.
Okay, so maybe I'll just leave it up this way. So calming the chaos in high conflict divorce matters. You know, no one wants to be in a high conflict matter. As you mentioned before, there are situations where sometimes you're the reason it's high conflict. Sometimes it's your ex. Sometimes it's the attorneys. Or it's just the circumstances of the case, because some issues do have to go into litigation. There is just no way around that. So let me just see, put in my next slide here. This is my bio, which mentions some of the things that you talked about in terms of my background. I have been practicing matrimonial law exclusively for more than 25 years. It is a passion of mine to represent parties going through conflict. And as you mentioned, I have a degree in psychology, which really comes into play, especially in high conflict matters. There's a reason why parties are embroiled in litigation. Obviously, it means one of the parties or their attorneys filed a case to get in front of a judge. In my practice, we do have a large practice here, considered a large practice. We have 10 attorneys here, one of the larger firms in the New York area. And what I've learned from all of the years that I've been practicing is that if there's a high conflict situation, almost always there were steps that led to that situation. There are attorneys that for whatever reason couldn't resolve the conflict, or the parties themselves decided that litigation was the right path forward because they needed to be in front of a judge. And so in this next slide, I'm going to talk a little bit about the power and control dynamic that either leads to resolving matters and keeping them low conflict versus making the decision that a case needs to go in front of someone with authority and power, and that's the judge. So as a plan A, when I take clients into our office, and we sign up many, many clients every week, we always discuss an initial strategy, if possible, of keeping the case out of court. And that happens when you have a client that is willing to cooperate and provide information regarding financial issues or custody issues, and being cooperative with their attorney, but also the attorney reaching out to the other attorney or to the other party and seeing whether there's a way to have a discussion or a meeting or an exchange of information that leads to resolving issues. And so here I have the three main things we're looking at when we're screening a client that's coming in to decide strategy. First of all, are there custody issues that can be resolved? Are there financial and tax issues that the parties can agree on? And finally, who has leverage in the case? Who has access to documents? Whose name is on the title of property or on a business? Who has control over the information, is willing to share that control? And finally, who has leverage? And leverage means who is in a position to really make concessions and make compromises and avoid potentially issues escalating and leading into a courtroom. So there are some aspects here that a client has control over and some that a client doesn't have control over. So the easiest issue is probably custody issues. And I say it's easy because the default starting point in New York State anyway, and many other jurisdictions, is some version of joint custody. And in most cases, parties with the attorney's cooperation and encouragement will almost always agree to some form of joint custody. In New York, sole custody is somewhat rare, and it's really preserved for a very small fraction of cases where you need to have a sole decision maker, and maybe even the other parent is not even going to be allowed access to the children at all. But that's a very small minority of cases, for sure less than 10%, at least in my practice. If you have a case where one party refuses to agree to joint custody or has a very good reason why there can't be joint custody, and I'm going to go into that, what some of those red flags are, then you need to go in front of a judge. In my practice, it's very rare that I would ever encourage a client to accept a sole custody agreement against them. Almost always, I'm starting with a position of joint custody, and this is what I'm trying to negotiate with the other side. I mean, again, sometimes I'll hear from the other attorney, not happening. Our client will not agree to joint custody, and here are the reasons why. And if it's an unreasonable position, we need to go in front of a judge. There is just no other way to resolve a conflict where one side has already taken a sole custody position. But sometimes it's my client that needs sole custody and has very good reasons why. It could be domestic violence, it could be a child abuse issue, it could be with a teenager who refuses to have contact with the other parent. And so there are times where, again, rarely, we will take a position that there has to be sole custody or supervised access or something really concerning that has to go in front of a judge. So going back to my slide here, family law and custody issues, I would say 90 to 95% of the time, this is going to be an issue where we can start with a discussion regarding joint custody. 5 to 10% of the time, we need to go in front of a judge. Either it's my client's position or my recommendation, or it's happening because of the other side. Many, many times cases will become high conflict. They will go in front of a judge. There'll be an attorney for the children, or maybe even a forensic examination or extensive protracted custody litigation. But even in those cases, at the end of the day, when an agreement is signed, or even there's a decision from a court, it is going to be a joint custody outcome in a divorce case. Family court in New York, especially when people go in without counsel, you're going to have different outcomes. The divorce landscape is quite different. Let me pause there for a moment. Lisa, do you have any follow-up, any questions before I move on to financial issues?
Yeah, can you just explain the difference when you just mentioned family court is quite different? How is that different and why?
So family court in New York really is set up so that parties, whether they're married or not married, or are going to court after a divorce, it's really designed for people to represent themselves. When parties are going through a divorce, they can, in New York State, proceed in both family court and Supreme Court. Supreme Court is where the divorce is going to be granted. And so it's very heavily discouraged to have proceedings in both courts. You obviously can't have judges in two different courts making decisions regarding custody. However, family court is also where parties will proceed in high conflict situations, maybe before a divorce has started, and especially in cases of domestic violence. And so any litigant, and this is men and women, although statistically most victims are women, can go into family court unrepresented or with an attorney and prove a case for domestic violence or maybe abuse of children, and they will get a sole custody decision much more, I don't want to say more easily. There are different issues that are prioritized in family court, and domestic violence, having a CPS investigation, child protective services, having rulings early on in the case regarding sole custody or temporary sole custody. Based on my experience, that is what family court does more easily. In Supreme Court, where divorces are granted in New York State, you can also have orders of protection. You can also have orders regarding domestic violence and protecting children and victims. But in my experience, you're not going to get a sole custody outcome that easily. And that it's because in divorce court, in Supreme Court, there are so many other issues that are part of what the court has to rule on. That includes child support issues. It can include spousal support. It includes rulings on evaluating businesses, disclosure and discovery regarding marital assets. It's a much more complex picture. And so there's not going to be putting custody at the front of the line the same way you would see in family court. At least again, in my experience. Does that make sense, Lisa?
Yes. Thank you for clarifying that. And for those who are watching, remember Jackie's firm is in New York, and these things can vary from state to state, jurisdiction to jurisdiction. So make sure that you are consulting with a legal professional in your area. But the information that Jackie is giving us is many times applicable in other places.
Yes, so yeah, the law throughout the United States is actually quite consistent in many aspects, including joint custody. So I know that when I speak to other attorneys from other states, I hear that joint custody is the starting paradigm. And it makes sense because we're coming through a pandemic. A lot of mothers and fathers were home with their children, spending much more time with their children and more involved in medical and academic decision-making. And more than ever, we have fathers that are stepping forward, asking for joint custody. They're expecting to get joint custody. And many of them are now asking for primary residential custody. This is another reason why we have more high conflict cases now post-pandemic than we did before. There are a lot of reasons for it. And I'm going to maybe tangent off a little bit just to mention that post-pandemic in New York, can't even call it post-pandemic. Maybe we're in the later stages of the pandemic because there are still many cases going on right now. But there was a backlog in the court system. New York has a tremendously large population, very, very active family courts and Supreme Courts. And so because of the backlog and because of just the pent-up demand, because we have now also a higher rate of people filing for divorce, filing for custody, more domestic violence cases than before. There's more funding for CPS, child protective services, so there's more investigations going on than ever before. Obviously, all of these things are geared towards protecting victims and children in many cases, but many of these lead to high conflict situations. So going back again, one step to what I was saying before, there's probably a third of our cases start out in family court, a third of our divorce cases. So there's conflict in the home, there's fighting, there may or may not be domestic violence, there may or may not be issues regarding children and even emergency issues involving children. So this generally leads people that are fighting to call the police. And then the police in New York tell people to go to family court. And family court is where mothers and fathers, husbands and wives can easily get orders of protection. There can be a refrain order, which is a more limited order. And in more extreme cases, there's a stay away order. Now, if a divorce hasn't been filed, this is where people are going to go to deal with these high conflict situations. And I have here on the slide now up in front of you some of the things that I call red flags in high conflict situations. And I'm going to go through some of these. I don't ever mean to discourage victims, people that are in danger or feeling afraid, to go to the police or go to family court. If you need to get an order of protection, that's exactly what you need to do. And in most states, orders of protections are given out quite freely. And it's because when a court system, when a government, when Child Protective Services becomes aware that there's violence in the home, it could be physical violence, it could be threats of violence, there could be a firearm, there could be verbal abuse. All of these things obviously are harmful to victims, and they're also harmful to children. Because even if a child is not in the room while the violence is going on, they're aware of it. Children that overhear threats, there could be substance abuse issues. Sorry about that. There could be substance abuse, there could be mental illness, there could be things going on where one party, one of the parents, is deteriorating or using substances or reacting to a partner who's using substances. So of course, people are going to call the police. And the police in New York tell people you need to go to family court because that's almost always where orders of protection are issued in New York State. But a few months down the line, after these orders are issued, a lot of times parties will get counseling, they'll get legal advice, and then they will realize we need to get divorced. This is really now the breaking point of our family. This is now a situation that cannot continue. And by the time the family court starts issuing orders, and this is very common in other states as well, there will be an attorney appointed for children. There will be mental health evaluations or maybe inpatient or outpatient treatment for substance abuse. And all of this treatment of the family and examination and scrutiny of the family is going to cause a tremendous amount of stress. And it's going to sometimes be the reason why parties will move on to let's start talking to divorce attorneys. So up to now, I've been talking mostly about high conflict in domestic violence and custody situations. And I've really recommended that parties get help, go to victim services, go to the family court, make sure your family is safe and you're safe. And almost all of these have to do with custody, domestic violence, and safety issues. But there are high conflict situations that come about because of financial issues and tax issues. And this happens every day now, again, during the pandemic, where a lot of people weren't earning income or weren't reporting income. A lot of parties have tax issues that have caused stress. And there are many cases where there are tax audits going on or financial issues that are coming to light now that parties are focusing on the relationship, maybe because of custody issues, but financial issues can definitely lead to high conflict situations. What I'm seeing a lot now are the mortgage isn't being paid. There's now notices coming in the mail regarding either tax issues or mortgage forbearance, or someone is not paying the mortgage, or one party is sort of hoarding their income, not contributing towards financial obligations of the household. And this can create a high conflict situation, because if you have one party who is refusing to do their share financially, pay the bills they used to pay, that's going to create a tremendous conflict. And I have many situations now where parties are living together, anticipating divorce, planning a divorce potentially, and doing things that are very self-serving. And that includes not paying bills. And when we have a client that comes to me and says, I'm at a point where I cannot afford to pay the bills on my own, my spouse is not contributing to the finances, I'm worried about losing my house, or I want to sell my house, and we need to do this because we cannot afford these bills anymore, and my spouse will not cooperate. So these are things that potentially will lead to a high conflict situation, an emergency application. These types of issues generally, these applications are brought in Supreme Court, almost always in divorce matters. And in New York, it's called a pendente lite application. That's a very similar terminology used in other states. It's a Latin term. It means temporary. So if you have a married couple with children in the home, in my area, it's mostly homeowners, not as many renters, but one party has stopped contributing, or one party is taking advantage of the other financially. Well, the way to deal with that, and it does take quite a bit of work, is preparing a financial application. There needs to be a financial affidavit. I'm sure, Lisa, you work with clients on financial affidavits. Usually takes a month or two to put together a comprehensive application to a court on a somewhat emergency basis, that there are bills that aren't being paid, there's risk to assets, there's transfer or waste of assets, there's one party who is in control, who has access to the assets or the income, or is not cooperating with the other party, and this is a form of leverage, and is really creating a scenario that is dangerous financially, either because of tax issues or financial issues. And now somebody has to go to court to get a judge to impose orders on the party that's not doing the right thing. So I have here now a list of some of the reasons why we have high conflict situations. Almost always the first thing that I see is a breakdown in the communication and cooperation. So parties that used to share the bills or contribute or communicate about bills for the household, for the children, there's now a breakdown in that communication. And frankly, Lisa, sometimes I just see there's a new girlfriend or boyfriend in the picture, or some recent infidelity, and that will trigger suddenly a high conflict situation. One party is not doing what they agreed to do, not what they're supposed to do. And so now you have this retaliatory dynamic between the parties. Another,
I'm
yes.
sorry, Jackie, I want to just make you aware, we've got about 3-4 minutes, Marcella, and I do want to make sure that we have time to talk about how to calm some of this as well. So
Yes.
Definitely.
Okay, so yeah, so let me gear into that. So if we these red flags are there, and I have parties coming in to meet with me to talk about it, either as a mediator or as an attorney, one of the most important things to do is to set expectations. And what I often tell parties is that there are assets. As long as it's known to the parties what the assets are, I can make pretty good predictions on how assets are going to be divided. What creates a lot of tension and conflict is short-term bill paying. And the decision has to be made. Can we try to reach out to the other side, the other attorney, to see whether we can get on the same page? And oftentimes we can, especially if the attorneys have a good track record and good working relationship. They will get on the phone or exchange emails and say, how can we put this back on track so that the bills are paid in some fair manner, and so we can stabilize the situation and avoid court intervention if at all possible, because it's so risky and expensive for both sides. And what can we do to try to create fair outcomes? It does take attorneys that are willing to really communicate with each other, send emails, send proposals, get on the phone, deal with emergency issues. Because everyone knows that if the lights get shut off or the house goes into foreclosure, it just drives up the expense and the anxiety for everyone. So I think the relationship with the attorneys, the willingness of an attorney to really jump in there and try to problem solve, it's key to de-escalating conflict. And a lot of it also has to do with what I tell clients is you have to transition in your mind from the husband and wife or partner dynamic to now a co-parenting dynamic. and really letting go of a lot of the negative emotions that come from a relationship, a marital relationship that's really not where it used to be. And as painful as that is, it really does mean getting into therapy, or really letting a client understand that there's a transition in the family, there are children in the picture, and now how do we make this into a co-parenting relationship? How do we get the expenses of the children paid in some fair way? And most of all, how can we separate these people sooner rather than later so they can move on to independent lives where they're a little bit happier? The hardest part is living together, especially when there's just misconduct going on. And then again, making the decision, how do we get this in front of a judge if we have to, because everything else we tried just didn't work.
Yeah. And I think a lot of what you've just said also goes to unrealistic expectations, one of your bullet points here, and that people many times believe they should get more than what they're being offered. You know, they're accustomed to living in the manner in which they've been taken care of, and there might not necessarily be enough income to support two households now, and that's a hard pill to swallow, and that can cause a lot of conflict. We found that in cases as well. So yeah, and also you mentioned in your list about substance abuse and mental health issues and all of that. So getting a therapist on board or getting someone into treatment has a lot to do with dealing with those cases, the high conflict and calming.
Yeah, I mean, you know, even though we're in an era of no fault divorce, and in most states it is no fault divorce, New York was the last state to adopt it. But, you know, I'm finding with clients, and maybe even especially the high conflict cases, that if you jump past the fault too quickly and start to get into financial issues and even custody issues before an individual is ready, I can see the fallout later on in the case. They need to process the fault. They need to process their own role in the breakdown of the relationship. There does need to be an emphasis on really forgiveness and, like I said, co-parenting, because even if you have two imperfect partners that are realizing that their marriage is coming to an end, that doesn't mean that this is a bad mom and a bad dad. A lot of times I can get parties that are very angry over an infidelity to admit that the parenting was actually good. And I need this person to help me raise these children. I need them financially. I need them to help, you know, if there's issues at school, or I need just a partner to help deal with issues with teenagers. It is very, very important for attorneys, for advisors to emphasize the benefits of co-parenting, and how essential it is to sort of get on that track that you are co-parents, and you need to exit this relationship as husband and wife, but still, you know, raise your children through the teenage years, you know, through their 20s, because even children that are adults need their parents in very significant ways. And so it is a mindset shift, and it does start towards the beginning of the process to really get on that path to forgive, and then focus on financial issues, which is really, in most cases, what divorce is about. Like I said, in most cases, joint custody is a given. Coming up with a schedule obviously needs to be done, but it's the money issues that really make the cases drag on. And then the counsel fees sometimes become the last issue to fight over. You know, who's supposed to pay for it? And in New York State, there is more and more of a trend where people have to pay their own legal fees, especially in high net worth cases. You have to pay your fees, and that's just the way it is.
Wow. Well, that was a lot of great information. And I hope that anybody who is listening live will stick around with us for the next half hour before we leave for our off-air time with Jackie. Marcella has a few things for us.
Absolutely. So we focused a lot today on what can create conflict. And so we've put together some tools that can help you to lower the conflict. Jackie gave us some really good advice and counsel about choosing the right attorneys that will work together. And in some cases, you may even want to start with things like the parenting plan. If you have children, you may want to start with the financials if that's the big issue in your marriage. And so we've developed a roadmap to give you some different ideas and tools of how and where you might start your divorce process to keep the conflict at a minimum. And this can be downloaded for free at divorcetimeusa.com. We also have a financial fitness kit. Again, this is a hot topic in every divorce. So to help get you organized and get answers even before you start, or if you're in the middle of a high conflict process, we encourage you to download the fitness kit right off the homepage of divorcemoneymatters.com. For those of you who are dealing with the emotional issues and are looking for another avenue or way of support, please join us. Again, this is a free support group, meetup.com, the Divorce Help and Hope Support Group. There you'll be able to meet with your peers and also have some professional moderators there to give advice or help or counsel along the way. So please join us for that as well. What do we have for you next week? Wow, next week we're going to continue with this theme of cutting down conflict, managing finances in divorce. We're going to talk about the do's and don'ts of divorce in the digital age. We have Howard Stewart, who's going to join us from Beam Forensics, and he's going to talk about the do's and don'ts of things relating to your technology and your devices while you're going through the divorce process. So please join us next week for that. As always, we want to thank you for joining us today. We hope you'll stick around for the question and answer in a few minutes. And we look forward to seeing you next time. Same place, same channel, new topic. Thank you everyone for joining us today.
Thank you.